Welcome to Litigation Corner, where we break down legal topics in an easy-to-understand format. I'm John Martino, and I am the Director of Litigation for Community Legal Services, a no-cost legal aid firm covering 12 counties coast to coast in the middle of Florida. Today we're discussing an issue that affects every single Floridian: housing. In the state of Florida, it is widely recognized that we have an affordable housing crisis. What does that mean? As reported by the National Low-Income Housing Coalition, out of 100 extremely low-income renters in the state of Florida, there is only 25 housing units available. That means 75% of low-income Floridians do not have a place they call home. That is staggering, and it also shows you how valuable housing is to people who have it and how devastating it can be to get home and see the eviction notice on your door. Today we're talking about paying rent and talking about the eviction process. Whether you're renting an apartment, house, or condo, knowing your legal rights is crucial. So if you have asked, is this notice on my door legal? Or can I fight the eviction process? Well, we're going to talk about it in this episode of Litigation Corner. Eviction is one of the most terrifying words for many Floridians. The ability to remain housed is core to a person's ability to pursue happiness in this country. And when that is threatened, it can affect every aspect of your life. That is why it is important for tenants to know their rights and for landlords to know what rules to follow. Today we're covering the eviction process. Florida law provides specific guidelines for both landlords and tenants, primarily found in Chapter 83 of the Florida statutes. Understanding these laws can help renters avoid unnecessary legal trouble and protect their rights. In Florida, landlords cannot remove tenants without following a legal process. There are only a few valid reasons for eviction: non-payment of rent, violation of a lease term, or the expiration of the lease without renewal. Each type of eviction comes with specific pre-lawsuit notice requirements. Proper notice must be given by landlords before they can file an eviction lawsuit. For the non-payment of rent, the landlord must provide a 3-day notice, allowing the tenant to pay in that time or vacate the rental unit. Please note that when I say 3 days, that does not include weekends or legal holidays. Also, I want to note, what we're talking about today is mostly about traditional rental units, and housing providers of subsidized housing may have different, longer notice requirements. Also, mobile home parks have special rules under Chapter 723 of Florida statutes. We will likely address the specifics of other housing situations in future episodes. Go into a second possible reason for removal. If a tenant violates the lease, the landlord must issue a 7-day notice, which could be curable, meaning that the tenant has a chance to fix the issue and remain in their property, or incurable, meaning that the renter cannot fix the issue and are required to leave after the expiration of 7 days. Now let's talk about the non-renewal of a lease. For week-to-week rental agreements, landlords must give at least 7 days notice for non-renewal. For month-to-month agreements, landlords must give at least 30 days notice before non-renewal of the lease term. The landlord must also take into account and not cut short a rental period once it has started, meaning that notice provided on May 15th does not necessarily mean that the notice permits them to remove the tenant on June 15th. They would likely not be able to remove the tenant until after June 30th. Now, when we're talking about notices, we are talking about the very beginning of the eviction process. The word eviction actually refers to the legal process filed with the court once the notice period has expired and the tenant has not left the rental unit. An eviction occurs at the end of a court proceeding when ordered by a judge. Landlords cannot take matters into their own hands by locking tenants out, shutting off utilities, or removing personal belongings without a formal eviction order. These actions are considered illegal self-help evictions under Florida law and are considered prohibited practices. If a court case is filed and the tenant proves that the landlord engages in prohibited practices, the judge has the ability to order the landlord to be responsible for at least 3 months' rent. Tenants are protected from retaliatory evictions. If a tenant reports unsafe conditions or asserts their rights, a landlord cannot evict them as retaliation, and retaliation can serve as an affirmative defense when litigating the eviction process. To explain what I mean by affirmative defense, it is helpful to take a step back and understand the eviction timeline. Let's say a rent payment is due on May 1st, and 5 days later no payment is made. The landlord provides the tenant a 3-day notice to pay or vacate. Only after those 3 days can the landlord go to the court and file an eviction case. The complaint will be public record, available to all, including future housing providers. This is why it is so important to avoid the eviction process if you can. Once the case is filed, a summons will be issued documenting the case. The summons will then be served on the resident. Service will take place when they are handed the summons by a process server or deputy sheriff. This is called personal service. Or the summons can be posted on their door, and there must also be a certificate that the document was mailed. Once the paperwork is received, the resident then has only 5 business days to file an answer, along with any affirmative defenses that they may have. It is also important to try to seek the help of an attorney immediately, because it would be best to talk to an attorney before filing an answer. Examples of affirmative defenses to eviction include failure to provide required notice, defective notice, breach of a duty to maintain safe and habitable condition, retaliatory eviction, and waiver of eviction, meaning that the landlord has accepted payment. Remember, if an answer is not filed timely, the case will be lost. Florida has a pay-to-play system, meaning to contest the eviction in court, the resident will have to pay all rent due into the registry, or file a motion to determine rent so the court can decide how much rent should be deposited. Note, the registry is a bank account owned by the court. In addition to depositing the rent already owed, tenants must deposit rent amounts accrued while the case is pending. If the tenant fails to timely deposit back rent and future rent while the case is pending, the case will likely be lost. If motion to determine rent is filed, at the hearing, the judge can decide if there is a reason for the resident to deposit less than the full amount of rent. For example, damage to the rental unit preventing the full enjoyment of the unit. During an eviction case, it is always possible that a resolution can be reached with the housing provider or their attorney. If a resolution is not reached, the case will go to a final hearing where the judge will decide if there are legal grounds that exist to support the eviction, or if there is a reason not to order the eviction. The main goal of the resident throughout the process is to try to avoid the eviction from being filed, and if it is filed, trying to avoid a final order of eviction, which could significantly impact the ability to obtain future housing. Keep in mind, if the judge issues an order of eviction, the sheriff can come to remove you from the property in as little as a day or 2. CLS has a housing unit dedicated to residents navigating this system and a helpline that can field questions about this process same day. In episode 1, we talked about how our helpline and our housing unit help Susan avoid eviction and maintain her housing. So remember, the eviction process is complicated. It is important that every tenant know their rights, know how to avoid eviction from being filed against them, and know how to defend against unlawful evictions. If you know someone who has been served with a notice to vacate their rental unit, please have them reach out to the Community Legal Services Helpline at 1-800-405-1417. Community Legal Services is here to help. That wraps up this episode of Litigation Corner. If you have a topic that you'd like me to cover in a future episode, please reach out to us. And remember that when you need help or a friend needs help, Community Legal Services is there for the community. See you next month in the Litigation Corner.